120 WPM English shorthand dictation. Be ready for it. Start. Para. On 1/2/2017, contending that the public information officer was found to have not supplied the information to which the petitioner was entitled, and therefore after the expiry of 30 days of moving of the application, the information has now to be supplied free of cost of the petitioner. Para. In the instant case, what has happened is that the order had been passed rejecting the application within 30 days. Thus, after the rejection of the application, there was no obligation on the part of the PIO to provide the information. Full stop. This situation is, however, different where the second appeal of the petitioner has been allowed on 7/11/2016. Full stop. The question is whether the limitation period of 30 days as provided for under section 7 in bracket 1 will continue to be available to the petitioner after the said order or not. Full stop. We find that the public information officer has to be compulsorily present according to the relevant procedure of appeals provided under the 2012 rules. It is not the case of the respondents that the PIO was not informed or was not aware of the order dated 7/11/2006. Full stop. It is otherwise also not possible in as much as if the appeal has to be heard in the presence of the public information officer, then the presumption is that the public information officer had fully and complete knowledge of the order dated 7/11/2016. Full stop. The providing of information of the passing of the order therefore is not an obligation on the part of the petitioner. Para. It is further submitted that the learned trial court, while convicting the appellants, had relied upon the alleged recovery of stolen articles from the possession of the appellants. Full stop. PW1 and PW4 had now were stated in their deposition that any stolen articles recovered from the possession of these appellants nor the person who identified those articles have been examined by the prosecution. Full stop. It is further submitted that even the officer who conducted test identification parade of stolen articles had not been examined. Full stop. Thus, the finding of the learned trial court regarding the recovery of stolen articles from the possession of the appellants is without any evidence. Full stop. In view of the aforesaid submissions, learned counsels appearing for the appellants had submitted that the impugned judgment and order of sentence cannot be sustained. Para. On the other hand, Miss Nandaprabha Shukla, learned additional government advocate appearing for the state, submitted that in the instant case the appellants were identified by 4 witnesses, therefore they have been rightly convicted by the learned trial court. Full stop. It is submitted that though the appellants were arrested on 4/1/1979, but some culprits arrested on 14/2/1979, thus there was no delay in holding test identification parade. Full stop. Moreover, para, the said delay had been explained. Full stop. Therefore, the delay in holding the test identification parade of appellants is not fatal for the case of the prosecution. It is further submitted that there is sufficient light at the time of occurrence, therefore the identification by the witnesses cannot be disbelieved. Full stop. Accordingly, it is submitted that the impugned judgment of conviction and order of sentence passed by the learned court below require no interference in this appeal. Para. Having heard the submissions, we have gone through the record of the case full stop. In the instant case, the factum of Ducati has not been denied, full stop. However, the appellants stated that they have not committed the present crime, rather, they have been falsely implicated in this case at the instance of police. Thus, the only question arose for determination in this case is whether the appellants have any hand in the full stop.